Today I want to talk about how private agreements affect where your money's going to go as a priority over your will document. And I got a true story. My name is Philip Roos. I'm an estate planning attorney here in Minnesota. So we had someone who came in. They were very upset. It wasn't a plan we had done. They had the will from their mom, and the will says that all the money goes to them. There was 2 children in the family. This was one of them. The other one was not. I wouldn't say disinherited, but not close. And mom said, okay, everything goes to this child. And this child came in and said, why is it that the will says everything goes to me, but I had to split mom's IRA with my sister, who doesn't even talk to my mom? Why did that happen? I don't understand. And of course, the first trigger is they want to sue, But you have to be a little careful of that, because here's the thing. Private agreements supersede the will. What a will does, a will is a court document. It goes through the court process, and anything that goes through the court process is going to be controlled by the will. Only things that go through the court process are going to be controlled by the will. There's lots of ways to pass on property, not just probate, not just your will. If I have a contract with someone, if I have a private agreement with someone that says they get it, well, they're probably going to get it. There's a lot of ways to do that. Beneficiary designations on your accounts, that's probably the number one thing. If I have a life insurance policy, an IRA, a 401k, a brokerage account, a savings account, and I go to the tab online that says, where would you like this to go when you die? It's called a beneficiary designation, or a transfer on or pay on death designation. And by filling this out, I'm creating a contract, a private agreement that says this person gets it. It doesn't matter what the will says. The will only controls things that go to probate. If I have an asset that skips probate, the will doesn't control it. The will is just the default. It's the instructions for the court system. So in this case, the will said child 1 gets everything. But the private agreement, the IRA beneficiary designation form, must have been very old, possibly out of date, but it said 50-50, and that's who's getting it. There's not much you can do about that. That's the statute. So, quick moral of the story, make sure your beneficiary designations are updated. They will control over the will. The will is just the default. If you're doing a comprehensive estate plan, your estate planning attorney is probably going to prompt you to get all of these things checked, and will even give you the proper language to give all these different companies to make sure things go to the right people the right way at the right time. Any questions on this, certainly do shoot us an email. Phil Roos at Stone Ridge Law Office.